Hi again, everybody. Dr. Klein here. I just wanted to take a few seconds, if I could, and I wanted to focus a little bit on how to go about briefing a Supreme Court case. For many of you, this is a brand new exercise, and you may have never actually read an entire Supreme Court case. If you haven't done that, I encourage you to visit the United States Supreme Court website. And on that website, what you'll find is, for at least the last couple of years, you'll find full syllabi of cases that have been argued in the Supreme Court, and you will see the rulings that SCOTUS has released to the general public. So if any of the high-profile cases in the last handful of years, you might be interested in what the actual ruling was, you can go on the SCOTUS website and they will provide you a full long documentation of what the actual decision was. But the issue is that some of these court cases, the decisions are 30, 40, 50, 60 pages long, and who has time to go through and read all of that? So one of the best exercises that we can do is trying to condense that information into what we call a case brief. Brief for a reason, right? It's in the name. So when we actually sit down to brief a case, there are a few things that we're going to be looking for each and every time that we brief. And I have provided you a series of lecture notes, or PowerPoints, if you will, on the Blackboard website, so you can follow along and see the structure of how a Supreme Court case should be briefed. And there's a few things that happen each and every time that you're going to do this. There's a set structure, and I've actually provided you with templates on the Blackboard website in each of the units that a Supreme Court case brief is due to me. And what you're going to start with every single brief is the actual case citation. So just like you would cite a paper or cite an article in a research paper that you're writing, you have to learn how to cite a Supreme Court case citation. And this can be a little tricky at first, so what I typically do for you all is I just provide you the citation on the first couple, and after that it's up to you guys to figure out how to cite the actual case. So on your very first case brief that you will do for me this semester, the citation is actually already provided, so you don't have to worry about that on the first one, but the lecture slides will provide you a how-to guide on how to actually cite the case for future briefs. So you're always going to start off with a case citation. Then you're going to work through the case history, the case facts, the issue of the actual case. So what is it that we're arguing? What was the holding or the ruling in the case? What is the significance of the case? In other words, why do we even care? And then what was the concurring and dissenting opinions? So each case, unless it was a unanimous decision, will have both a concurrent and a dissenting argument. And in that concurring argument, you're going to have the majority opinion. So if the case happened to be a 5-4 vote, you need to have a winning deciding vote one way or the other. If it was 5-4, the justices that voted on the 5 side of it will have provided a concurring argument, and normally one justice is elected to write that concurring argument. On the flip side, the 4 justices that are in the minority all get together and write a dissenting argument. There might be other dissenting arguments within the larger scope of the dissent, but for the most part, the dissenting argument shows the reasons why we disagreed with the majority justices in this decision. So I'm going to break these things down a little bit further for you, so just how you sort of go about this in more detail. So the case citation, I'm not going to go over too much because there is a very detailed slide in the lecture slides that I provided for you that show you how to do that. Sort of just plug in the holes and fill it the way you would any other reference. But I want to jump to the case history. So it's very important to know that between the case history and the case facts, we're talking about two very different things. And a lot of times what I see with my students is that they sometimes get the history and the facts confused, and they lose points on their briefs because they sort of double dip and put the same information for both. The case history is separate from the case facts, and in the case history what you're really looking for is the legal history of the case, not the facts of the crime. So not what the defendant actually did, but the legal history of the case itself. So what court did it start out in? So it normally is going to be a state case, right? What court did it originate in? Then after that case, where was it first appealed to? And then how did it make its way to the United States Supreme Court? So there's a progression that we're looking for when we're talking about the history of the case. So what kind of case is it? What was the history of it? Who were the parties? What was the original outcome for the defendant? On what grounds is the defendant appealing? So, all of that great information. That's different from the facts of the case. The facts of the case are now the actual facts. So what happened? If we're talking about a homicide case, what was the surrounding information that sort of ties into why the defendant killed this person? If it's a drug case, what were the surrounding facts, sort of linking the case together in terms of what happened in the actual case. So all of the great details that students want to give me about the who, what, where, all of that good stuff about the case, this is where you put it in. You put it in the facts of the case, not the history. Make sure that those are two separate items when you're going through and doing your brief. After the facts, after the history and after the facts, then we have the issue. And the issue, think of it this way. The case in question has made its way all the way up to the United States or the state Supreme Court. So most often when we're talking about this case, there is a constitutional issue at play. So you can't execute me because of my 8th Amendment rights are in violation, or you can't punish me because my 4th Amendment rights against unlawful search and seizure were violated in this case. So most often when we're talking about a United States Supreme Court case, we're talking about a constitutional issue. So it's up to you to figure out what the argument is for this case. I'm appealing on these grounds because of this reason. So the issue is the legal question. What is it that the defendant or the appellant in this case, what is that individual trying to make an argument on? That then ties into our holding. So we have a legal question, then we need a legal decision. So in our holding, this is the decision. The Supreme Court ruled 5-4, 6-3, 7-2, whatever it may be. So all of these cases will have a decision in there somewhere. Here's the trick. You need to count justices sometimes. The United States Supreme Court, if it is fully appointed, will have 9 justices on the bench. So you will have something that adds up to 9. Here's the other trick. If we're talking about a state Supreme Court, each state is different and does not necessarily have a 9-seat bench. So some of these cases you first need to figure out if it's United States Supreme Court or if it's a state Supreme Court, and then you need to figure out how many justices sit on whatever state we're talking about, sit on that bench. You then need to count and see how many are in the majority, how many are in the minority opinion, and that will get you your vote. So if you're looking in the concurring argument and it says that Justice so-and-so, so-and-so, so-and-so all vote this way, and you have 5 names, you now know that it is a 5-4 vote if we're talking about the Supreme Court. So the holding has 2 things. First, it has the vote, and then it has the actual decision. So was the decision affirmed? Was the decision reversed and remanded? You have to figure out what the actual ruling was and what was the rationale in a brief sort of sentence as to what the rationale for that holding was. Then in the concurring and dissenting arguments, you're going to have a larger picture of why the court voted the way that it voted. So in the significance of the case, what you're going to look for is why the case is important and what does this decision do for all future cases. Remember that when we're talking about legal cases, we're talking about legal precedent. So if I have already ruled a certain way, like let's take the Miranda case, for instance. We all know our Miranda rights. If we are arrested, somebody has to tell us that we have the right to remain silent, so on and so forth, right? So the Miranda case has set legal precedent for all future cases. And if an officer does not read me my Miranda rights, the court knows that it is supposed to throw out that case, right? So the significance of the Miranda case is that from here on, from all cases forward, that has to take place or a legal violation has occurred. So case precedent for whatever case we're talking about has some significance moving forward. It is your job to figure out what that actual significance is and how this case is important to all future cases. What is this case going to establish moving forward? And I have a few other questions on the significance portion of your case brief lecture so you can see and kind of go through and figure out, you know, some of the thought patterns you should be having as you're moving forward on figuring out what the significance of the case really is. And then finally, in your case brief, you will have both the concurring and the dissenting opinions. And basically what these are, the concurrence, as I told you, the concurrent argument is the majority justice's opinion and why they all voted the way that they did. The dissenting argument is the minority justice's opinion, and all of those justices disagreed with the majority justices, and they explain why. So in the concurring and dissenting opinion portions of your case brief, you need to break down the arguments for the concurring and dissenting opinions, and you need to explain to me why the majority voted this way and the minority justices voted that way. And then finally, the last thing on your case brief template is your opinion. This is very important because as you're going through and you're breaking down these legal decisions in the Supreme Court cases, what you need to be thinking about is whether or not you agree with the ruling. So you might be sitting there and saying, I cannot believe that the justices ruled this way. If I was on the Supreme Court, I would have never upheld this decision, or I would have reversed this in the blink of an eye. This is clearly a constitutional violation. So you need to be thinking in that way as you go through and you read these Supreme Court cases. You need to figure out whether or not you believe that this decision was a good decision or a bad decision, and you need to tell me why. Do not leave this portion out of your case brief. If you do this, I will give you an automatic 0 for that section. Okay? It's very important to me that you go through and you give me a legal opinion of your own. And don't just give me a 1 second or 1 sentence, I agree with the court. No. You have to tell me why you agree or you disagree, and you better be putting in some kind of legal language that tells me and explains to me that you have really taken the time to look through this case and you have dissected the legal arguments properly. That's important to me, and it's important to your grade, so make sure that you actually go through and do that part. Now, I just want to sort of end this brief mini lecture by telling you that the first time you will do this, you're going to be frustrated at me, you're going to be frustrated at the court, and you're going to be frustrated at this assignment. It gets easier. The very first time you do this, it will be a frustrating thing. Do not leave this assignment to the very last minute. Make sure you give yourself plenty of time to actually go through and to be able to type this up in language that is your own. Please do not think that because this is a different kind of writing assignment that you have the ability to go through and just copy paste everything from the actual Supreme Court case syllabus. If you do that and you plagiarize, you will get a 0 for this assignment. It is up to you to paraphrase, not plagiarize, this assignment. So please paraphrase in your own words. And I understand that might be difficult to do at first because you're trying to break down language that comes from the Supreme Court, but I know that you guys can do this. Be strong at paraphrasing. Do not rely on copy paste. It will hurt you in the long run. The last word of advice that I have for you guys: you may be strongly tempted to go online and find a Supreme Court case brief that has already been done. Let me tell you, this is not the first time I have done this assignment. I do it every single semester. Every time I do this, without fail, somebody has tried that, and without fail, they have failed the assignment and they have been reported to the Honor Code Conduct Committee. Okay, I will do it. This is your one piece of warning. So please do not go do that. I hate to have to call up those folks, and they know me over there. I don't want to have to do it. So please don't force my hand on this. It's not that difficult of an assignment that you have to go and look for outside help online, okay? So please don't do it. I'm looking for original work. I'm looking for original paraphrasing. I'm looking for original breaking down of these cases and trying to just dissect the legal nuance that is contained within them. If you need help and you don't wait until the very last minute, this should not be a very difficult assignment. But if you need help, if you need a guideline to sort of show you the first time going around with this, please get in touch with me. I'm more than willing to help. I know these cases inside and out at this point. If you need help, come see me, call me, email me. Don't wait until the last minute and think that you can do this, because when 11:59 rolls around, I'm expecting a completed case brief that looks as though you spent the week trying to figure this out, okay? So like I said, get in touch with me if you need help, but I think you'll be okay. You have enough resources. Also online, I have provided you with a sample case brief of the Marbury v. Madison case. You will not be doing this one in class this semester, so I felt like it was appropriate to give you a sample brief for that one, so it sort of shows you some of the legal language that I'm looking for. But again, you should be coming up with original briefs. So I'm going to leave you guys with that. I know that this is a lot to take in the first go around, so really just sit down for a little while and try and read and figure out the nuance of this case. And I sort of look forward to what you guys are going to turn in. This is always an exciting opportunity for you guys to learn a new structured type of assignment. It's always exciting for me to see what you guys turn in. So if you need any help, get in touch with me. If not, I will see you on the other side. Good luck, guys.